subject of constitutional review has, of course, engaged our attention for some time now. This week, or last week, I happened to come across this news item in one of the international presses that posed the question, Ghana, no longer an African role model? And the question had arisen in the light of the publication just a day before of the Mo Ibrahim Governance Index and its rankings for Africa. And in the latest release of the Mo Ibrahim Governance Index, Ghana had dropped. The quality of Ghana had dropped by I think 1.5 points each of the years between, I believe, 2007 to 2016. And the study had also indicated that the fall in the quality of governance in Ghana was also correlated with decline in the quality of development, broadly defined. And for some, this would come as a surprise because I think that we tend to see, especially we Ghanaians, tend to see Ghana as, indeed, when it comes to matters of democracy, we tend to see Ghana as quite a leader on the continent. And indeed, Ghana is a leader on the continent, but that means for it to be seen as a leader, you have to actually disaggregate the matter into these two components. First, when it comes to running elections and doing beautiful transfers of power, indeed, Ghana is a leader. We run very peaceful elections. We do not have very contentious, or in fact, we don't have contentious transfers of power between winner and loser. When the case, even when the case goes to the Supreme Court, we are quite civil about it. The loser just basically goes away. There's no Raila Odinga trying to get sworn in separately after Uhuru, that kind of stuff. So we do those things well. What we do not do well, however, is govern in the period between elections. So it is not surprising that, in fact, because a lot of the coverage of Africa when it comes to politics and democracy has to do with these first issues, issues of the freeness and fairness of elections, issues of election disputation, issues of term limits. Many presidents over the continent are unwilling to leave when their terms expire. The president of Congo's term expired about a year ago. The guy is still staying put. So you don't get that kind of negative story coming from Ghana. And to that extent, yes, we indeed are a leader. What the Mo Ibrahim Index is trying to suggest, however, is that in the period between elections, we govern very poorly. Right? So what it appears is that we have mastered the rules, if you look at it as the rules of the game, right? We have mastered the rules of entry and exit, how you enter the game to play the game. We've mastered those very well. We do very well with the rules of entry and exit. But when it comes to the rules of play, once you have entered the game and you have to play it on a day-to-day basis, you have to govern, we do it very poorly. Right? And the question is why? Right? So some, of course, have laid blame on the doorsteps of the Constitution. Others dispute that, right? So if you take the range of views on this matter and put them on a spectrum, on one end you would find those who think, on one end are those who think the Constitution is fine, it has nothing to do with this. And then the other end would be the radicals who think the Constitution has everything to do with this. The Constitution is deeply flawed. And then, of course, there are a range of opinions and viewpoints in between, from one end of the spectrum to the other. Some of the opinions veering close to there's nothing wrong opinion, and others closer to the radical opinion. The there is nothing wrong opinion, in my view, is the opinion of the establishment class, of the insiders, those who operate the Constitution, those who run it on a day-to-day basis, the political class, so to speak. They do not think there is a whole lot that is wrong with the Constitution. But they are not alone. There are others too who have looked at the Constitution and said, well, the Constitution is okay as it is. In fact, it's been described as one of the best constitutions. I've heard some describe it that way, right? And so they say that it's really the operators of the Constitution who are to blame. It's the politicians. It's our politics. It's the people themselves. It's not the Constitution. And in fact, that is a respectable opinion. It's an opinion. I have had this debate with many who have worked the Constitution many, many years. They have spent their careers in politics, and they will tell you it's not the Constitution. And this is a very bipartisan view, right? So we've had two of the main parties that have contested power here and alternated in power in this country. Both pretty much share the view that the Constitution is not broken. And if it is not broken, you don't fix it. Right? So that is the view. Then there are those who believe that too many of the kind of governance problems we're talking about are too deep, too embedded in our politics, too embedded in the culture for it to be cured any other way except through constitutional review. And because we have had two parties having played this game over time, and we've seen these problems persisting, we are now able to at least make some conclusions. That is not really the type of the kind of political party in power that explains these problems. So take one of them, the spoils system. Whenever there are elections and there's a transfer of power, we see this huge convulsion in our politics. People being thrown out of office, new ones coming in, foot soldiers seizing toilets and motorway booths and stuff like that. Right? That has occurred with both parties. It is a deeply entrenched spoils system that treats politics and electoral politics as almost as war, and the victors as entitled to the spoils of war, so that the vanquished have to give up whatever it is that they had, and the victors have to inherit the spoils of war, which practically means that livelihoods are lost. Of course, certain offices cannot endure or cannot survive the defeat of the incumbent government, ministerial appointments and many others. But we're not talking about those. We're talking about the kinds of jobs on which we depend for the day-to-day running of the country, some of them quite lowly in terms of the hierarchy in the public service system. So we have this entrenched spoils system that has persisted regardless of who wins power. We also have seen what we've described over and over again as the imperial presidency. The presidents in this part of the world, regardless of their own personal dispositions, have huge power. They pretty much are the monarchs of all that they survey and look actually quite monarchical in the way in which they exercise power. There's very little to stop them. We've seen, for example, huge expansions in the size of government. The presidents have no limits. So the Constitution is also very profligate. Right? As a result of this, the president's power has caused the Constitution to become so profligate, which means that the Constitution is a very expensive thing to actually operate. And it's not expensive in the sense in which we say, oh, democracy is not cheap. Democracy is not cheap, but it doesn't have to be needlessly expensive. But here you have a Constitution that allows the size of government to grow infinitely, right? Just absolutely without limit. Can create more and more office. As long as the president wants an office to be created, he just can mint one today. And he doesn't have to go through parliament to pass an act establishing a Ministry of Culture and Religion or a Ministry of Railways. He can just name a minister and then the ministry just develops around the minister the next day. The president wants more districts. Come on, more districts. Regions, maybe goes through a little bit of hustle, but not not a big deal. You can get an office, a region established. So we have created a system where the constitution is becoming quite costly to operate regardless of who is in power. And local government too. So you have this system of local government that gives us a very weak local government. It doesn't give us what we really have is not local government, it's local administration, right? So basically these local districts are essentially just branch offices of the national, and the president appoints the chief executive and that kind of stuff. And on and on and on. And we also don't have a system where it appears that once you get elected into government here, once the system, this is a country where the citizens exercise their rights as the people, we the people, about once a year, once every 4 years, sorry. So once we elect a government, we are pretty much, the government takes it as a license to rule unhindered for 4 years. Very little public participation. And it's not just because citizens are unwilling, that's also one factor, there is no real demand. But in some countries, you have actually a right to participate in a number of decisions that the government makes on a regular basis. And sometimes in the South African Constitution, for example, if Parliament were to pass a law and failed to actually consult particular stakeholders before passing that law can be deemed unconstitutional. And it has happened with some laws, so that you have a right to public participation in the legislative process, not at the grace of Parliament. Here, sometimes Parliament calls you, CDD, we have this law, can you come and we'll do a retreat? No, you have a right to public participation. But here, we don't. Essentially, at the mercy of the legislative branch. So there are a number of defects with the way we operate government. And the question is, are these constitutional problems, or are these to be blamed on politics? My own view is that those who insist that the Constitution is not to blame and that this is really a matter of politics not working, I think fundamentally misunderstand the nature of the relationship between a constitution and politics in a democracy. And here, in my view, is what the relationship is like. Constitutions fundamentally regulate politics. What constitutions do really is to regulate politics and political power. They set the ground rules on the basis of which the game of politics will be played. Both the rules of entry and exit into that game, as well as once you get in the game, the rules of play, how the game will be played, are basically what constitutions are about fundamentally. Okay. Once we understand that conception of a constitution, then you would see that, in my view, we can then define broadly two kinds of constitutions, right? Not the ones that we know in law school, written on those ones, but something that this is my own coinage, right? So you can have a constitution that is regulatory on the one hand, or you can have a constitution that is permissive on the other hand. The regulatory constitution would be that kind of constitution that regulates a lot of things, right? It looks at the political process. It regulates politics quite heavily, right? There are rules for a number of things, do's and don'ts in many places, right? It doesn't leave a lot of room for politics to fail. And then there's the permissive one that just really creates a little framework and just leaves politics to do the rest of it, right? And normally constitutions regulate in two ways. They first give you power, which every constitution must do because governments without power cannot run. So a constitution first must give you power so that you can constitute government itself and be empowered to act. But constitutions also do a second thing, which is almost contradictory but necessary, which is once having given you power, then they must turn around and constrain you and put limits on how that power must be exercised. So some do, some don't, how you use power, how you don't use it, and the like. The regulatory constitution does both, in my view, very well, right? It empowers, but also heavily regulates or constrains the use of that power. The permissive constitution donates power to the political class, then steps back and doesn't regulate very much, so that it leaves a lot of room for politics to then fill the gaps. Because what the Constitution does not regulate, it implicitly permits. Right? So what the Constitution does not regulate, it implicitly permits. And in our system, my argument is that our Constitution is highly permissive. Highly permissive. It's left a lot of gaps to be filled by politics, and therefore by party politics and by politicians. And a number of the problems that we see have survived and endured one party to the other, partly because the political rationality, the political incentives just completely lead you that way. Right? It doesn't matter how well-intentioned you are, if you're given that much power with no constraint or with very little constraint in how you exercise it, you are likely to exercise it a particular way. Let me give one example. So there's nothing in the Constitution that says that presidents may or may not appoint members of parliament to sit on the boards of public corporations or state enterprises. Nothing. Nothing one way or the other. The Constitution basically doesn't regulate that area at all. It just leaves it to politics to figure out. How do you think politics will figure that out? Nothing in the Constitution says MPs must sit on boards. But if you look at the logic of a legislature has oversight of the public administration. It oversees public agencies, MDAs, ministries, department agencies. How do you have a member of parliament turning around to sit on the board of, say, State Housing Corporation or any of the corporations? And then when the matter, let's say there's some malfeasance on that corporation during your tenure as a member of parliament on the board, and the matter comes to parliament, how are you supposed to act on it? Right? So as a matter of best practice, it's not done. But this is not regulated by the Constitution. The Constitution leaves it to politicians. And so what do you think that the politicians would do? Government after government, president after president, has appointed members of parliament to sit on boards, because that's the political logic. The political logic, when you leave things to politics, they are resolved through party politics and political logic. That's how it's going to be resolved. So we have no limits on the number of ministers. And we don't have to have an act of parliament to establish a ministry. How do you think that will be resolved if you leave it to politics? It will be resolved in accordance with the incentives that drive politics. So the numbers will keep creeping up. As long as there's somebody knocking at the door wanting to be minister very badly, there'll be one more person nominated to be minister. That's how, when the Constitution is permissive and leaves matters to politics, that's how politics resolves it. It resolves it in accordance with political logic. It is rational from the point of view of the politician. Maybe my phone is telling me I should just wind up. So that's one way I see it. I see these gaps as indeed not, so this is how I see the relationship between politics and the Constitution. So when you say that, it is not the fault of the Constitution, but it is politics, I think it's actually quite a secular argument you're making, because essentially it is the Constitution that has allowed the politics, right? It is the permissiveness of the Constitution that has allowed the politics free rein to operate. And therefore, you can't say that, well, it's not the Constitution, it's politics. It's actually the same thing. We come back to the same thing. But for us lawyers, probably you say, well, but those gaps, so how do we fill those gaps there? It still doesn't answer the question whether or not constitutional review or reform is how we should fill those gaps. So we've identified the gaps. We can even say that they are constitutional in origin. But how do you fill them? The lawyer trained in the case method and trained like all of us are in Marbury versus Madison and all of it, we said, well, the Supreme Court can fill the gaps. Why not? The courts will fill those gaps. And that's actually one response you usually get. When you say, well, there are gaps. So of course, you have to leave some gaps in the Constitution. And mind you, I'm not saying that there's anything wrong with politics. In a democracy, you must have a constitution and you must have room for politics, because that's how we do the game of democracy. So there has to be politics, by all means. The question is, how much room for politics and how much must be regulated by the Constitution? And my argument is that in our democracy, Constitution regulates politics very little and has left a whole lot of room for politics to play. And as a result, we see these kinds of problems that cannot, because of the nature of political incentives, cannot be resolved by the political class. They have no incentive to close any of those gaps. So who should close them? Well, the Supreme Court. That's a normal lawyer's response, especially a common law lawyer's response. Well, the problem, of course, is that the Supreme Court is a reactive institution. You have to go to the court with litigation. Okay, so somebody has to take the initiative of going to court, and somebody must find a particular gap in the Constitution so worrisome that they are motivated to go to court first. So there has to be a demand for litigation. In many societies, that would not be a problem. For the Americans, that would not be a problem. There's almost like a lawsuit a minute. But in many other places, that's going to be a problem, actually. There are many rights in the Constitution that have not even been activated. I call it, rights without plaintiffs. There are people whose rights are violated all the time, but have no idea, no inclination to even go to court in our system. So the idea that we must rely on litigation as a way of curing some of these gaps and defects in the Constitution is not necessarily a very attractive option. But assuming that there was even litigation, you have to deal then with the second factor, which is that you go to court and the outcome is indeterminative. I mean, you cannot just sit and say that, well, if we go to court with this case, this is how the court is going to rule. Right? So you can go to court with a particular problem about the Constitution and come out worse off, make the Constitution even worse off. Right? And I've had this battle with my good friend Kwasi, whose real activism in sending cases to the court has really helped to generate quite a bit of a body of law for us that is helping to actually build our constitutional jurisprudence. But sometimes we have those arguments when he wants to file a suit and I say, Bakweku, you're going to lose this one. Not because I think your case is without merit, but I think if you look at the court and its jurisprudence, this one, you're going to lose it. And we are going to be worse off the day after the decision comes out, because before you went, at least it was constitutionally indeterminate. Now you're going to go and the court is going to just close that gap in a way that reinforces the status quo even more, right? So there are no guarantees. Even if judicial review is what we're looking at as a way to fill the gaps, there are no guarantees that the gaps will be closed in a particular way that's beneficial to good governance, right? There are many things that courts have done. For example, in the US, after the 14th Amendment was passed after the Civil War, the 14th Amendment is that amendment to the US Constitution that was passed to give the freed slaves equal rights as citizens. Right? The Protection Clause has been passed. It's in the Constitution. But some states were still asking black people to sit at the back of the train or in the smoking area of the trains with the smoking cabins and the like, and the whites were sitting on one at the end of the train. So somebody challenges this in the Supreme Court. It goes all the way to the Supreme Court. This is unconstitutional. We are being denied equality under the law. And what does the Supreme Court say? The Supreme Court says, in the notorious case Plessy versus Ferguson, there's nothing unconstitutional about that. You see? So here you are, you go to court, because at the time, it depended on the state. Some states were allowing more equality for blacks, others were not. But once Plessy versus Ferguson came down and the court said it was not unconstitutional, can you imagine what happened? Many, many states then started putting blacks at the end of the train and the bus. So it made it even worse. So sometimes judicial review can give you a worse outcome than before you went to court. So I don't find that a very reliable option. What about conventions? In fact, sometime last year, 2 years ago, the president of the bar at the time approached me and a few others and said, we've had some conversations with some leaders in the political class about building certain conventions around the Constitution, this idea of conventions. So one way you can close some of these gaps is by developing useful conventions. So for example, the Constitution leaves the president free to appoint the chair and members of the Electoral Commission. Okay, so it doesn't seem to sit well with those who think that, well, if you are a participant in the game, if you are the team playing the other team and you are the captain of the team, you shouldn't choose the referee. That's the easy analogy, the lay analogy that is often given. And it tends to resonate with a lot of people. It tends to make sense to a lot of people. But the Constitution leaves it to the president. If he wants to consult informally with the opposition and come to a consensus on a candidate before they are nominated, the president can do that. So in some other places, conventions where there are gaps like that are left to be filled by politics, conventions can develop around these particular provisions so that those gaps will be closed through political consensus in a way that is beneficial to good governance. That's one way to do it. But the question is, how is it going to be done? Who is going to take the initiative? Who is going to be the first politician to do it? It would look like unilateral disarmament. You are fighting a war and you've just tied your hands at the back and the other side. You don't trust if it gets to their turn, they'll do the same thing. So sometimes you tell people, look, do we have to remove every CEO of a state enterprise when we come to power? Say, yeah, but they did it. You see, the other side did it. If we don't do it, when they come, they will remove our people, you see. So how do you develop conventions in a system like that where there is so much distrust politically? Right? So that route too, the route of developing conventions as ways of closing the gaps, because in fact, in some countries, I mean the UK doesn't have a written constitution as such, right? But they've been able to live off of conventions for generations, for centuries, and it works. The system works. As I said, there's a lot of political consensus about certain things that nobody, it's almost become constitutional. You dare not breach it. You will not breach it. The Queen knows that there is no law that says that the royal assent, when a bill is sent to the Queen to sign, there is no law that says the Queen must sign it. There's no constitutional provision in Britain. But the Queen will never not sign it. Right? That's a convention. It has developed over time that it has political legitimacy across the board, and no one faction of the political class has what it takes to actually go against it. And yet it is not law. Right? So that option is also there, but how does it work? How will it work in this place? So far, the conventions we have developed are almost on the negative side. We have almost, where there are gaps left, we have in fact developed conventions, which is that when you come and meet a CEO, you throw them out. That's a convention. That's one convention. It's a convention in the other direction, right? And we have done many of such conventions with all of the gaps that we have left in the Constitution. So that leaves us, if we can't close these gaps perfectly by judicial review, and if we can't close these gaps by convention, then how else are we to do it? Legislation, of course. Legislation is one thing. You can pass laws, but that's politics, right? So legislation is really one way in which you fill the gaps in the Constitution. You pass laws to fill those gaps. But again, that is essentially saying that politics will fill it, right? Because what legislation essentially means is that a particular government's political agenda is done in the form of a bill, taken to Parliament, and with a majority, a Parliament approves it, right? So that can be done that way. But it is not, doing it that way really doesn't solve the problem, because another government can come and repeal it very easily, and that same government can actually change its mind and repeal it. So really, I think that, I'm going through all of this because the advertised program talks about theoretical justifications for constitutional review. And I believe that the case that I make for constitutional review is that because of the permissiveness of the Constitution and because of the gaps that have been left, the defects that have been left, that have been resolved or will inevitably be resolved through political logic. The kinds of governance problems we have begun to encounter since the Fourth Republic and that are beginning to take root and endure and become part of our political culture will not be resolved through judicial review. In fact, some of them do not even lend themselves to the kind the kind of stuff you can take to court. And if you took it to court, some judge would actually look at it and say, this is a political question. We don't resolve these things through litigation. Right? Some of them, many of them don't lend themselves to litigation. And even where they do, there's no guarantee that they'll be resolved in a manner that is favorable to good governance. And of course, conventions are very difficult to develop when you don't have a certain minimal consensus between the political class, and especially even with the electorate. We also don't have to forget that when you have a permissive constitution like ours, it puts a lot of strain and burden on the public. You have to have a very activist public that pushes the political class to do the right thing. But do we have that kind of a public? Do we have that kind of a civil society that can organize behind certain agendas and say, look, in the best interest of the country, this has to be done this way. We know that you guys do tit for tat, but that doesn't inure to the benefit of the country. Do it this way. Do we have that kind of a public? Do we have that kind of a civil society? And I think that the answer, again, to those questions is a no, and that leaves me with no other option but to support constitutional review. We can talk about what kind of constitutional review, whether or not the Constitutional Review Committee's recommendations are the right kinds of recommendations, but at least I think that what I've tried to do in my very long introductory remarks is really to make the case for why constitutional review is, in my view, not just desirable, but necessary. Thank you.